Welcome to Strategic Justice in Action with David Senoff.
Hey everybody, welcome back to an all-new episode of Strategic Justice in Action with David Senoff, founding partner over at the First Law Strategy Group. I am your host, Mike Leon. David is a plaintiff's attorney focused on appellate advocacy, insurance bad faith, and public policy litigation that holds corporations and governments accountable. And in today's episode, we're talking about what it means to represent institutional clients like counties, unions, benefit funds, when the goal isn't just compensation, it's about accountability and public protection. David's going to explain it all in just a second. So, David, good to see you as always. Let me ask you at the high level here. When you're representing a county or a union fund, that's obviously different than representing an individual. What makes these institutional cases unique from the start?
Well, Mike, thanks for having me, and thanks for shedding some light on this topic. I mean, what makes it sort of different than representing an individual is a lot of times these cases, particularly for health and welfare funds, for unions or counties, is that the money that you're fighting over is typically money that was either paid by union members into the union fund as part of their dues or paid by taxpayers. And what you're really trying to do is, for example, in a case about medication like opioids or other drugs, you're really trying to get these counties or health and welfare funds reimbursed for money that their members or taxpayers have already paid, but paid for something that they probably shouldn't have paid for through no fault of leadership, either at the county level or at the union level, through no fault of theirs. And so it really does take on sort of this high level, like we're trying to redeem we're trying to redeem the rights of all of the people in the county or all of the members of the health and welfare fund.
So let me ask you, when a local government or fund decides to sue, how do they define success from the suit? Like what outcome matters the most to them beyond the monetary part of this?
I mean, look, let's not kid ourselves. When anybody starts a lawsuit, particularly for money damages, money is sort of the number one goal. However, in other cases, for example, if you're filing a lawsuit as a health and welfare fund because your insurance company won't cover a particular drug, right? And maybe that's caused some harm to your members and you're trying to get their premiums back, whatever the case may be. One of the goals is to get what we call declaratory relief from the court, which is just an order from the court that says, hey, insurance company, going forward, you have to pay for this drug. And so a lot of times the union health and welfare funds, even the county benefits people, will describe success as the ability to get that particular, whatever it is, drug, surgical procedure, whatever we're fighting over, approved in the future for people who are going to need it, for their members who are going to need it going forward, who may not need it right now. And so in those cases, there's no money. We're not fighting necessarily over money. We're fighting over what's going to happen going forward.
So these cases oftentimes involve taxpayer or member funds. How do you balance that legal strategy with the responsibility that, it's the use of public or collective resources that are involved in this?
I mean, we always try and remember two things. One, like you said, it's public or union funds, and that's funds that people worked for and either paid taxes on, or that people worked for and had withdrawn from their paycheck and expected a certain level of benefits from their union health and welfare fund. And so that's always our priority in cases where we're seeking these kind of money damages. Now, at the same time, these cases frequently end in settlement, right? And a settlement in these cases is not unlike every other settlement, which is to say you never get 100% of what you think you lost, right? By definition, a settlement is settling. So we try to maximize the settlement as a percentage of the loss, but frequently, either because there's so much litigation about a particular topic against one defendant that they could never afford to pay, more than 40 or 50% of every plaintiff's claim, or because the amount that they offer just doesn't get to a substantial amount, but in exchange, they're willing to make a change in their operating procedures. And so that's very, as we were just talking about in the last question, that's very important to us, because a lot of times, however much money has been spent to date often pales in comparison to what the amount of money might be in the future when you just calculate the amount that would be spent if no change in behavior was made by the defendants. So, that a lot of times the funds and the counties consider as much or even sometimes a bigger victory, because they know that they're not going to be forced to spend this money going forward.
David, in your experience, what's a big misconception out there about why these counties or these unions file lawsuits against corporations?
There's a couple. I mean, I think the biggest misconception is that somehow they're talked into it by the lawyers, right? That the plaintiff's lawyers show up at their doorstep and knock on their door, and they're trying to get these counties to file a lawsuit for reimbursement of opioid costs or for lead paint abatement or whatever the case may be, when in reality, these issues have been bubbling under the surface of both the counties and the health and welfare funds for sometimes years, right? I mean, they themselves, the executives at both public and union funds, see the numbers, see the accounting numbers, see the money that they're spending, and they know what the problem is. And oftentimes they can't figure out a solution within their sort of legislative ambit or within the union's negotiating power. And so then they turn to lawyers. So I would say the first big misconception is that the lawyers are driving the cases as opposed to the clients driving the cases. I think the second misconception is that the counties and the unions are doing this for, for millions and millions of dollars, right? Which, I don't think any of these cases that has settled on an individual union or county basis has ever yielded millions and millions and millions of dollars. And that what's really going to happen is that the union or the county is going to put it in some kind of rainy day slush fund to be used in the future at the whim of the leadership, right? That, in my experience, that has never happened. Usually what happens is that money goes back into the health and welfare fund or wherever it came and is used to purchase more benefits for the members. So it's not, nobody's lining their pockets with the money that's recovered in these cases.
Yeah, very well said there. So let me ask you, when multiple public entities, for example, they join forces on this, what are some of the coordination methods that help maintain this united front?
It's the recognition that, a lot of times at the beginning, what happens is the counties and the unions are all jockeying to be the first case filed, right? Because if you're the first case filed, sometimes, depending on where you are, you have more control over the litigation. So at the beginning, sometimes there's some jockeying for who's going to be first and who's going to lead the team. But once all of that is sort of settled, and people file the cases and the cases are going on, you'd be stunned at the agreement you will have around the room with regard to how to proceed. And I don't just mean amongst, lawyers who have been doing this for 30 years. I mean amongst the actual leadership of the various unions or the leadership of the counties. I mean, sure, there's some difference about who should get to settle first or who should go to trial first. But those, again, are all logistical issues. But you'd be, like I said, the people that we have been fortunate enough to work with are all pretty much public servants in the just plain English definition of that phrase. They're really just trying to do the best that they can for their constituents, whether their constituents are the general public in the case of a county, or the members of a union in the case of a health and welfare fund. I mean, I remember when I did one of my early cases, and I was stunned at just how public service oriented these people really and truly are. And it's amazing to watch once the case gets going and you see that everybody's really rowing the boat in the same direction without really too much prodding from the lawyers.
It's good to hear. And David, how do you prepare these clients for the scrutiny that's going to come with these large scale public litigation?
We always tell them to be very circumspect about what they say to the press, to be circumspect about what they share when they're in these meetings with their attorneys, right? Because, it's one thing when you're meeting with a client one-on-one, the client expects there to be an attorney-client privilege. But of course, with the union, there's also an attorney-client privilege. With the county, there's an attorney-client privilege. And while for sure, all the leadership of these organizations have a right to know what their attorneys are saying, there does come a point where you have to continually counsel your clients like, listen, yes, everybody up to this certain level can be brought in to what we're talking about here, but nobody else, or else you run the risk of wiping out your attorney-client privilege. The other thing that we always tell them is, and we tell this to all our clients, always tell the truth when you're in court, because, not telling the truth when you're in court or filing something that's not true is bad. It's not just bad for the lawyer, it's bad for the county, the client, and it's bad for your credibility going forward. And I stress all the time to particularly these institutional clients that your credibility going forward is all that you have, right? Because you've brought this lawsuit, you're the plaintiff, you have to prove that you're in the right, you have to prove that the defendants did what you said they did, and the only way you're going to do that is to maintain your credibility.
David, let me ask you, when you're working with these type of cases, they involve complex damages, sometimes public health impacts. What kind of experts in those type of cases tend to play the most critical roles in the matters?
I say all the time, we all should have been experts because, it takes a village of experts. Let me put it that way. So for sure, you need some kind of health expert, right? So in case of lead paint, you need experts who know what happens when people ingest lead paint, just to tell you that. Then you're going to need, if it's a case about a product, you need experts who can discuss the history of the product, the purchase of the product, how the product came to be in the county, right? How the product came to be purchased by the health and welfare fund, for example. You need experts, forensic experts, accounting experts to be able to quantify the damages. And then finally, you oftentimes need statistical experts, right, who can do two things. One, explain how much was purchased in the past and how it was purchased. And two, in those cases where you're trying to get relief, going forward and you're trying to affect a policy change, how if there's no policy change, will that affect the county or the union? And conversely, if there is a policy change, how that will affect the county and the union. So, yeah, like I said, we all should have been experts, and it takes a village of experts.
Well, we would argue you're an expert here in this stuff. So David, let me ask you then, because these institutions, I'm sure, face pressure in terms of maybe settling early. How do you weigh that short-term relief against the long-term accountability part?
I frequently am asked to address a larger group. Like typically in these kinds of cases, there's one person that deals with the day-to-day interaction with the attorneys, but then I'm frequently asked to address, like a larger board of directors or county commissioners. And what we always say is, when you start the case, you have to understand they're going to try and buy it cheaply. And even though we, the lawyers, think it's cheaply, that number may not be a number that you think is low. And we tell them to sort of behave as if they know that there's going to be another day to fight. You don't always have to accept the first offer, and that you're really trying to vindicate a larger right, that it's not just about the money, that yes, even if you only got this amount of money, you would count it as a win. But if you got this amount of money and some kind of promise to change future behavior by the defendant, it would be that much better, right? And frequently what will happen is they will want to take the money, and we'll go back and we'll say, all right, look, the money is okay, but let's talk about a policy change, right? Let's talk about some kind of label. Let's talk on a product, or let's talk about what you're going to do going forward to help the members of the union or the citizens of the county. And, you'd be surprised that a lot of times companies are, once they hear that you're willing to accept whatever the number is that they've offered, they're much more willing to present changes in their forward-looking behavior to help the group of members or the citizens of the county.
David, as we wrap here, what have you learned about the role that litigation can play in protecting these communities when the policy alone isn't enough?
I will say that what I've learned is that these kinds of public policy cases can affect change, sometimes faster, right? But oftentimes sort of more efficiently than waiting for the process to grind through, particularly, and I'm talking about the process outside of court, right? Particularly if this has been whatever the issue is, has been a problem for years and years, and it seems like there's no solution, right? When the problem is so intractable that you can't figure out a way to get it done, oftentimes turning to the courts will speed that up. I mean, I think about not a case that I did, but, cases about voting rights, lawsuits got the Voting Rights Act passed. It was a lot of people filing a lot of lawsuits to vindicate their right to vote, which ultimately got the Federal Voting Rights Act passed. And that's how I see these kinds of cases, right? Eventually, the pressure from the legal side will force a response on the legislative side.
Yeah. David, thank you for the time and insights on this. Truly appreciate it, as always.
Thank you, and it was great to be with you.
And thank you to everybody out there listening to this episode of Strategic Justice in Action. If you want to learn more about the work that David and his team are doing over at First Law Strategy Group, do me a favor, visit firstlawstrategy.com. Thanks to everybody for watching. Leave us a comment, review, subscribe so you don't miss the next episode, or share it with somebody who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks, Mike.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.